All right, my friends. I just pressed the Let's Go Live button, so let's wait for the stream to fire up all across the fruited plain of the internet. On this lovely and very beautiful Friday, we've got some serious business to attend to. I think the Supreme Court dropped a case or opinion or two, but we can't get into it until we can make sure the tubes are connected. And it looks like the tubes are connected, which is tremendous news. Let's go ahead and get started, shall we? Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live, the show that spotlights misconduct involving police, prosecutors, and politicians. My name is Robert Gouveia. I'm a criminal defense attorney, and today we are talking about student loans being canceled. Supreme Court coming out. You just heard thousands of students screaming out in one unified voice into the universe, "Brah!" Or rather, "Ree!" One of the two. We're going to talk about it. Also, not going to be any compulsory mandates for business owners to make websites that they disagree with. And so we'll go through that opinion as well. That one was drafted by Judge Gorsuch. We've got the full opinion of 303 Creative versus Elenis. We'll go through it. We've also got the student loan cancellation. That opinion was drafted by Judge Gorsuch. By Chief Justice Roberts. Gorsuch is down here. And so we'll go through that. Biden versus Nebraska. And then we're going to see what's going on across the pond over there in France. Because apparently France is experiencing a summer of love, my friends. A summer of love. We had one of those a couple of years ago. Our version was also fiery but mostly peaceful. And you can see they're experiencing some peace and harmony in France as well, all in the name of equity and justice or whatever. They're running through buildings, ransacking vehicle dealers to get some of that equitable justice as well, and they're smashing the library, which contains patriarchal misinformation. It kind of looks like a scene out of Mad Max. You can see this is literally what it looks like. There's just a police car. It's not good, man. That's society. This is real life. Could be coming to a city near you. This is the police, apparently 40,000 of them charging, all been activated. You just drive down the roads. It is a total disaster. And so we'll go through that. Now, apparently, the timeline has been going on for a few days, and Macron, the leader of France, was dancing to Elton John, man. It was Pride Month still. It's not over yet. So he's out there just getting groovy with it while his country burns. You know, they said Nero fiddled while Rome burned. Macron dances while Paris melts. So we've got a lot to get to today. We'll spend some time on the Supreme Court stuff, get the heavy lifting out of the way. And of course, it is a beautiful, beautiful Friday, and it is July 4th weekend. I know a lot of people are celebrating, hopefully safely and soundly. I know there's been a lot of travel nonsense going on out there. And so wherever it is, whatever it is you're doing, we appreciate you joining us. Also want to shout out our community, watchingthewatchers.locals.com. It's our locals community. And we do member-only stuff. And, there'll be some interesting posts this weekend as we travel around northern Arizona. And watchingthewatchers.locals.com is where you can join us, where we also do Trump docket updates. We've got our private Telegram group for our members. And it's a lot of fun. I actually, just this morning, had a great meeting with locals, the director over there. Her name is Vivian. She's awesome. And they're rolling out a bunch of new features, including some live stream technology. They're kind of repivoting towards live streaming in a lot of ways to really beef up those technologies, including permanent chats over there and different banners and different systems. So it's very cool. And I'm very excited about what we're building. We'd love it if you joined us, watchingthewatchers.locals.com. Also, you can join on YouTube and you get a lot of the same stuff. And one of the other things we talked about on Locals was a price increase, which is going to be coming in August. And so there'll be more about that. It's going to be an August price increase, but we'll talk more about that. So if you haven't joined yet, then now's a good time to join because we've got about another month and then the prices will go up. But if you're joined now, you're going to be grandfathered in and it's all going to be good. So nothing for you to worry about now. But we also are going to have our Field of Greens sponsor in the house because it's the weekend. We're going to be barbecuing and out in the sun a lot. And it's going to be, just a lot of hot debauchery in some places. But we can't go on without being properly fortified. And so let's, my friends, make sure we go over to Field of Greens, where we can all lose some leftover pandemic pounds. And look, I know how sick of the weight loss ads and the fad diets and all that stuff. You know, you've all tried it. We've all tried it. We've all done it. They just don't work. But you know what does? Eating 5 healthy servings of fruits and vegetables every day. You do that and the weight would probably just fall right off. But vegetables, not a fan. And fruit, who's got time to prepare that every day? Not me. Instead, let's talk about Field of Greens. Now, Field of Greens is a science-backed formula, very specific fruits and vegetables that you won't find in any other product. Proper nutrition reboots your metabolism so you burn calories faster and lose weight a healthier way. And Field of Greens is the only brand backed by a better health promise. Yes, you'll look and feel healthier fast, but the greater proof comes at your next checkup when your doctor says, wow, you've lost weight. Whatever you're doing, keep it up. So let's get you started. Go on over to fieldofgreens.com and visit fieldofgreens.com and use code Robert when you check out so that you can save 15%, baby. And there's a lot of other good stuff there. It's not just the Field of Greens. There's other health products for you. So just load up your cart with whatever your heart desires and save 15% at checkout. All right. And so when you're eating those barbecue ribs this weekend, celebrating the birth of America, make sure you're also getting your greens. All right. So let's get into the real meat and potatoes today. Major victory in the Supreme Court. We have the Biden student loan scam that they were trying to squeeze through using some obscure COVID protocols, saying that the pandemic justified the executive branch of the government just unilaterally writing off, waving away with a wand, huge swaths of debt. Doesn't really work that way. Congress passes the laws and the executive branch executes them. And it seems like the Supreme Court agrees. This opinion came out in Biden versus Nebraska. It's a 6-3 opinion drafted by the Chief Justice, John Roberts. And as soon as this opinion dropped, we heard in a great unified voice, thousands of students scream in despair for having to pay their bills. Now, this is what the opinion sounds like. It came out from the October term out of the Supreme Court of the United States of America. We're going to go through the head note here, and they tell us that the Education Act of 1965 is the governing law. This is the rule. And anytime we go through legal analysis, we often will break legal analysis down into a framework called IRAC. I-R-A-C. And this is issue, rule, application, conclusion, or analysis and conclusion. And some law schools, they'll want you to shove a little bit of an E in there for an explanation of the rule. So IREAC, issue, rule, explanation, application, conclusion. So it's the parts that you need in order to come to a good legal analysis opinion. You got to have these different things. So they're telling us that the rule is right here. It's the Education Act, 1965. The act governs financial aid mechanisms, including student loans. Now, the act authorizes the Secretary of Education to cancel or reduce loans in very certain limited circumstances. And this is what they said, oh, COVID gave us this excuse to just do whatever we want. The law says the secretary may cancel a set amount of loans held by some public servants. Look at the law. He may also forgive the loans of borrowers who have died or become permanently disabled, those borrowers who are bankrupt, another provision of the law, and borrowers whose schools falsely certify them close down or fail to pay lenders. All right, so the law, they're saying specifically, gives the Secretary of Education rules that they have to follow, and the rules say that this can only be applied in certain circumstances. So the issue here that's been presented is about the authority under the law, under the act called the HEROES Act. And can the Department of Education deviate and depart from existing provisions of the Education Act and then suddenly establish a student loan forgiveness program under this new act that will cancel about $430 billion in debt, just like that? Boom. And affect nearly all borrowers. Under the HEROES Act, the Secretary may waive or modify any statutory or regulatory provision for financial assistance as the Secretary deems necessary, here it is, in connection with a war, military operation, or national emergency. Did we just have one of those? Oh, yeah, we did. Or at least they told us we did. As relevant here, the Secretary may issue such waivers or modifications as, quote, may be necessary to ensure that recipients of financial assistance are not placed in a worse position financially because of the national emergency. So, the Biden administration, they just latched onto this provision and they said, perfect, COVID's been a national emergency. A lot of people are going to be in a worse position, really because they locked us all down and because they mismanaged the response in massive ineptitude fashion. So all of this is their justification. They say, well, I mean, we really want to buy these voters off, especially before the midterms. How can we possibly do this? I know what we'll do. We'll just tell them we're going to waive thousands of dollars from their bills. That's a good payoff. And they'll never know better. They'll vote for us, and then it'll get struck down by the court later. In 2022, as the COVID pandemic came to its end, says the Supreme Court, the Secretary of Education invoked the HEROES Act and then suddenly issued waivers and modifications, reducing or even eliminating the debt of most borrowers. Borrowers with eligible federal student loans who had an income under $125,000 in either 2020 or 2021 got eligible for a balanced discharge of up to 10 grand. Woo! Nice. That's a nice little payoff for those voters. Those who previously received Pell Grants, a specific type of federal loan, qualified for up to $20,000. So what happened here? 6 states challenged the plan. They said, you don't have this authority to do this. Department of Education, Miguel Cardona. You can't just write off $400 billion of debt. The 8th Circuit, when the states sued, issued a nationwide preliminary injunction, meaning the court said, yeah, you're right. They cannot just start writing all of this money off. And the court, when these lawsuits were going through, the government appealed, and now we're in the Supreme Court. Now, they give us a little bit of analysis here about standing. Missouri at least has standing. Why? Because they say they do, they spend money, and so on. But the crux of the opinion tells us the HEROES Act allows the Secretary to waive or modify existing law, regulatory provisions that are applicable to financial assistance. Does have that power. But the HEROES Act does not allow the Secretary to rewrite the statute to the extent of canceling $430 billion of student loans. So what often happens is we have laws that get passed, and then we have regulations that come after the laws, and the regulations are how to apply the law, right? Congress is not that smart. So they write these laws saying, oh, this is the law, this is where the money goes, and so on. And then you'll have what's called the Code of Federal Regulations will often write regulations to interpret and apply the law. And so you'll have laws, and then you'll have regulations, and then you'll have other interpretations of the regulations, and it's a real complicated mess because that's our government. But here, this portion of this is only supposed to be interpreting the law, not supposed to be rewriting it. And what the HEROES Act has been doing, or what the Secretary of Education has been attempting to do under the HEROES Act, is to rewrite it, not just interpret it. And rewriting it to just cancel money. So the Supreme Court says, the text of the HEROES Act does not authorize this loan forgiveness program. The Secretary's power under the Act to modify does not permit them to permit basic and fundamental changes to the scheme. Instead, modification under the rules, it carries a connotation of increment or limitation, just slight adjustments at the margins. It must be read for moderate changes or minor changes. That's how the word is ordinarily used and defined. And a legal definition is no different. So the authority to modify statutes and regulations allows the secretary to make modest adjustments in addition to existing provisions, but not to transform them. Judge Roberts continues. He says, prior to the COVID-19 pandemic, modifications issued under the Act were minor and had limited effect, but COVID changed everything. We know that now suddenly property rights don't matter because emergency. But the modifications challenged here create a novel and fundamentally different loan forgiveness program. They just created it out of thin air. While Congress specified in the Education Act a few narrowly delineated situations that could qualify a borrower for a loan discharge, and we covered those here. We saw those three delineated. That if you had any one of these provisions, if you were permanently and totally disabled, okay, discharge, the law says that's cool. You're bankrupt, okay, law says, all right, you've got nothing left, so you can maybe discharge some of those. And if you went to a school that is closed down and they failed to pay, well, then you can maybe get exempt. But otherwise, the law says it's pretty much clear. Now you have been adjusting it and extended this to discharge nearly every borrower in the country. Every borrower. It's highly unlikely that Congress authorized the sweeping loan cancellation program through the subtle device as permission to modify. But the government, the secretary, and the Biden administration, they respond. They told the Supreme Court, they said, hey, sorry guys, this act does authorize us to waive legal provisions as well as modify them. So we're not even going to modify them, we're just going to waive them. And that this additional term grants even broader authority than the word modify. He says, well, we're not going to modify anything, we'll just waive it then. But the Secretary's invocation of the waiver power here does not remotely resemble how it has been used on other prior occasions, where it was simply used to nullify particular legal requirements. The Secretary, Miguel Cardona, next argues that the power to waive or modify is greater than the sum of its parts. Because the waiver allows the Secretary to eliminate legal obligations, the combination in the law, if you mash these two words together, called waive or modify, it's like 1 + 1 = 3. You get new powers. It must, just by logical extension, allow him to reduce them to any extent short of waiver, even if the power to modify ordinarily does not stretch that far. But the court says, the challenged loan forgiveness program here, it goes beyond even that. In essence, the Secretary has drafted a new section of the Education Act from scratch. Just wrote it by waiving provisions root and branch and then filling the empty spaces with radically new text. Because if Congress won't give them what they want, they just do it anyways. The Secretary from the Biden administration also cites a procedural provision in the HEROES Act, directing the Secretary to publish a notice in the Federal Register, including terms and conditions applied. Now, in the government's view, they say that language gives them permission to waive and put our own requirements into law. The court says no. But rather than implicitly granting the section and the Secretary authority to draft these things, this part of the law simply imposes an obligation to report the waivers. You don't get to make new ones, you just got to report it. The Secretary's ability to add new terms in lieu of the old is limited to his authority to modify. As with other modifications, you cannot distort the fundamental nature of the provision. So they say here, in sum, the Secretary's comprehensive debt cancellation plan is not a waiver because it augments and it expands previous provisions dramatically. It's not a modification because it constitutes effectively the introduction of a whole new regime. And it cannot be some weird Frankenstein combination of the two, because when the Secretary seeks to add to existing law, the fact that he has waived certain provisions does not give him a free pass to avoid other limits to modify, quote. However broad the meaning of waive or modify that he wants to use, that language cannot authorize the kind of exhaustive rewriting that has taken place here. The Secretary responds, and this is John Roberts writing. He says the Secretary also appeals to congressional purpose, saying, they passed this law and they wanted to grant substantial discretion to the Department of Education in the event of unforeseen emergencies. That's what Congress intended. The court says, okay, well, on this view, if we accepted that, the unprecedented nature of the Secretary's debt cancellation plan is justified by the unparalleled scope of the pandemic. But the question here is not whether something should be done. It's who has the authority to do it. As in the court's recent decision in another case, given the history and the breadth of the authority asserted by the executive, the court has reason to hesitate before concluding that Congress meant to confer all of that authority. Remember, we have three branches of government, and for some reason, our Congress is so weak and pathetic that they often just delegate stuff over to the executive branch to do. And you'll find this in your local states as well. Your state legislatures will also say, it's really complicated for us. I don't want to deal with it. Why don't we give this power over to the Secretary of State? And it happens all the time. And so now the court is saying, wait a minute. If Congress is going to give over to education the power to just nuke $500 billion in debt, automatically, that's not going to be the standard procedure here. We are going to put some speed bumps in this and not just defer to Miguel Cardona's authority. This case implicates many of the same factors present in other cases where we had similar separation of powers concerns. The Secretary has never previously claimed powers of this magnitude under the HEROES Act. No regulation on this has even begun to approach the size or the scope of this program. The economic and political significance of this action is staggering. And the Secretary's assertion of his newfound administrative authority has conveniently enabled him to enact a whole new program that Congress has chosen not to do itself. That's why we have a Congress. The Secretary argues that the principles explained in the West Virginia case and its predecessors should not apply here. But major question cases have arisen from all corners of the administrative state, and this is not the first such case to arise in the context of government benefits. Roberts says, all this leads the court to conclude that the basic and consequential trade-offs inherent in a mass debt cancellation programs are ones that Congress would have intended for itself. And so in these circumstances, the court has required the Secretary to point to clear congressional authorization to justify the program. But the HEROES Act, as the government points to, doesn't provide that authorization. In fact, it provides no authorization for the Secretary's plan when examined using the ordinary tools of statutory interpretation, let alone asking for clear congressional authorization. So therefore, because the statute doesn't say you can do this, it says where you can waive and what you can waive in limited circumstances. This is not an appropriate executive action. It's in violation of the law. Signed and delivered by Chief Justice John Roberts. This is a 6-3 opinion, split along party lines. We've got Thomas, Alito, Gorsuch, Kavanaugh, and Amy Coney Barrett joining the majority. And we've got Kagan, who wrote the dissent, with Sotomayor and Jackson joining in the dissent. So this is what the main opinion looks like. And I want to just fast forward. We read through the head note. And so I want to fast forward back over to the dissent so we can just get a little bit of a taste of it and see what they're saying. And so we're fast forwarding down to this. Amy Coney Barrett concurs. And here we go. This is the dissent. Judge Kagan dissenting. joined by Judge Sotomayor and Judge Jackson. They say in every respect, the court today exceeds its proper limited role in our nation's governance. So they want themselves to have less power, I guess. Some 20 years ago, Congress enacted legislation called the HEROES Act. The Secretary's authority was bounded. He could do whatever was necessary to alleviate emergencies. But when COVID hit, two secretaries decided to use their authority, and they suspended loan repayments and gave them extensions. The second continued that policy and then decided to give $10,000. And so now the court is overreaching. They're really upset about standing, an injury. We do not allow that plaintiffs bring claims when they haven't been injured. So basically, they're saying this case should have never been brought. For years, this court insists that we should keep policy decisions out of our judicial roles. And they say they're just disagreeing with the interpretation of the statute. They say the statute, the law, the one that we just read, says that it does give the secretary broad authority to give emergency relief to student loan borrowers, including, look, by altering usual rules. When the secretary did, fits within the delegation, but the court forbids him to proceed. So this is just generic statutory interpretation stuff. And the majority has the majority. The Republican conservatives have the majority in the votes. They're going to read rules strictly and try to interpret it literally on the basis of what the law says. The left, the liberals, oftentimes are looking at purpose and effect and outcome. What does the outcome lead to? And they want student loans to go away, essentially. I mean, I think they want the communalism. I think they would like to just federalize student loans, quite frankly, and the education system. So this is impeding that effort. And it's also a hurt for their team, for the Biden administration. So it's not really much more complicated than that. The court today is now accepting a case without standing. In other words, they shouldn't have accepted this case. And therefore, this violates the Constitution because we are hearing it. And so that is the opinion. You can see the rest of this. It's a 77-page opinion. The dissent finishes. So in a case, not a case, they say this is not even a case that should have ever been brought. The majority overrides the judgment of the legislative and executive branches, which I disagree with. I think they're overriding the judgment of the executive branch, not the legislative branch. And eliminating loan forgiveness. Look at this. 43 million Americans, the dissent says, are going to be implicated by this. 43 million Americans thought that they were going to be getting 10 to 20 grand off their loans like that because the Biden administration lied to them and tried to squeeze this one through. And it's completely unconstitutional. It's not even contemplated in the secretary's power. The majority gets it right. The dissent doesn't. The majority actually read the law and says, look, here are the provisions that the law allows right here. Section 1078-10, Section 1087A1, 1087B, 1087C. This is where you can discharge and waive loans. You can't do it for 43 million Americans because you want to win the midterms. And there will be more of this. You know, the law is what the law is, but the people who are in charge are still going to be the people who are in charge. And so whether the court comes out with an opinion one way or the other, they're not going to stop. They're going to continue to try to find other ways and other mechanisms to waive the student loans, to federalize the education system, to make more of a communalism approach to everything that we do, where the government has more power, the citizenry doesn't. The people who paid their student loans off, who worked their butts off, and paid their bills down, don't get the same benefits that other people do. And the U.S. government doesn't follow the rules in order to get that done. If they wanted to go through Congress and Congress passed a bill that said, we contemplated this as a society and we all sat around and said, gosh, do we want to spend $100 billion on American students and education, or do we want to spend $100 billion on some foreign war some other place? What do we want to do? And if Congress came out and said, $100 billion for Americans rather than for defense contractors, and they came up with a plan and they waived student loans or whatever at that point, that would be a different conversation, because that would be more democratic, to use their words. It would be the correct process, and there would be a lot less to argue about. But this is not that at all. This is the Biden administration saying that we have authority to do whatever we want. And they're dishonest about this. They knew they didn't have this authority. Anybody who reads the statute knows that they didn't have this authority. They tried to write off $500 million, $500 billion with the stroke of a pen. And they're going to continue to do it. It's a slap in the face to their voters, to these 43 million people who were led into this narrative that this was all going to be possible, who may have been planning for it, all got rug pulled courtesy of the Biden administration. And it's going to continue to happen. This is the failure of government. The government promises solutions that can never be delivered. And for some reason, people will still keep following the leader of the Democrats right off the cliff. All right, my friends. So that was the first opinion. Good news for sanity. And it's just amazing that they even tried it. But we know why they tried it. And it may have worked. It really stopped a good portion of maybe a lot of the momentum back during the midterms. So, all right, we've got another opinion to attend to. This is another interesting one. And it comes from our boy, Judge Gorsuch. New addition to the court and a Trump appointee. Here's what this one says. A major Supreme Court opinion comes out written by Judge Gorsuch. It's in the case of 303 Creative versus Elenis, and it was a 6-3 decision, split right along party lines. And it involves the creation of websites by businesses for people with whom they disagree. In this case, the allegation was that Colorado mandated that business owners provide services for LGBTQ websites, and a business owner who was not interested in making one of those websites wanted to clarify her rights and authorities. Here is the case. It is 303 Creative versus Elenis. And this is a 70-page opinion that comes out of the Supreme Court of the United States of America. And just to see who is drafting this opinion, we see it is Judge Gorsuch. He's joined by Roberts, the Chief Justice, Thomas, Alito, Kavanaugh, and Barrett. They make up the majority, 6-3. Once again, joined by the liberals in the dissent. Sotomayor is drafting this one, and Kagan and Jackson join in. And so let's see what the court held for us after a little bit of background from the head note. Lori Smith is the person who is the subject of this case. Now, she wants to expand her graphic design business. It's called 303 Creative. She also wants to include services for couples who want wedding websites. Making websites out there. But Miss Smith worries that Colorado is going to use a new anti-discrimination act to compel her, in violation of her First Amendment, to create websites celebrating marriages that she does not endorse. Kind of like the cake baker who had to bake the cake. The caker. To clarify her rights, Miss Smith filed a lawsuit seeking an injunction to prevent the state of Colorado from forcing her to create websites celebrating marriages that defy her belief that marriage should be reserved to unions between one man and one woman. So Colorado has this law And it doesn't sound like anybody has actually asked her to create a website, but there is a law that says the following. In Colorado, it's known as CADA, C-A-D-A. CADA prohibits all, quote, public accommodations, presumably meaning her business, which she doesn't know yet. Is my business a public accommodation? I don't know. But it prohibits all public accommodations from denying the full and equal enjoyment of its goods and services to any customer based on his race, creed, disability, sexual orientation, or other statutorily enumerated trait. The law defines, quote, public accommodation. We don't know exactly what that means broadly. Is this just like government entities, parks and swimming pools? Or not? The answer is not. In fact, public accommodation means almost every public-facing business in the state. You do business, guess what? You're a public accommodation. Either state officials or private citizens may bring actions to enforce the law, one of these. So this woman, right, if she now says, I'm now making wedding websites, and a same-sex couple goes in and says, we'd love a website. She says no, they now have a legal cause of action. They can sue her for that. They may bring action to enforce the law. And if they're successful, penalties can follow any violation. So we don't even know what the threshold is to bring the claim. But if somebody walks in there and says, hi, we're a same-sex couple, we'd like a website. She says no, boom, I imagine that's a violation of the law. They record it and they say, oh, she didn't make a website. So then they file a lawsuit, and I don't know if she becomes strictly liable for this or what, but regardless, the process is the penalty. So now she's got to defend herself and hire a lawyer and say this, now social media, it's a big nightmare. So she's filing saying, all right, well, I need to know this. Like if I have to make these websites, maybe I'm just not going to go into that line of business. Maybe I'm just not going to do wedding websites. So before the district court, when they land there, Miss Smith and the state agreed to a number of facts. They did a stipulation, which is just a signed agreement. They both say, this is true. We think it's true. They think it's true. One, nobody's arguing about this. Miss Smith is willing to work with all people regardless of classifications such as race, creed, sexual orientation, and gender, and will gladly create custom graphics and websites for clients of any sexual orientation. She will not produce content that contradicts biblical truth, regardless of who orders it. All right? Miss Smith's belief is that marriage is a union between one man and one woman. It's a sincerely held conviction. So she's not making this up. And just to be clear on this, it wasn't that she's going to just automatically deny same-sex couples websites. That's not true. It's going to be about websites dedicated for a purpose that contradicts the biblical truth. So anybody of a sexual orientation who is a same-sex couple who comes in and says, hey, we want a website. Oh, what's it for? Well, we're starting a business. Oh, that's great. What do you want on it? Sit down, sign a contract, here we go. No problem at all. But if it is somebody who comes in and says, oh, we're getting married, that's a different story. Because it's her biblical conviction, it's her religious belief, and that is a sincerely held belief. And we've had a lot of other legal jurisprudence about this. Some people will say, I smoke crack. And you say, oh, really? You smoke crack? What's that part of? Like Hunter Biden could have used this defense. He could have said well, crack's part of my religion. And they would have said, what religion is that? Crackhead religion? And they would have said, no, that's not a legitimate religion. And you don't, believe that you need crack to fulfill your religious obligations. Nice try, Hunter. But maybe the FBI bought it. Maybe that's why he didn't get charged. I don't know. We'll have to ask them. But that's not the case with Miss Smith. She provides design services that are in alignment with her sincerely held convictions. Expressive. She says when she does her work, it's original, it's customized. It is a creation that contributes to the overall message that her business conveys. Through the websites it creates, the wedding website she plans to create will be, quote, expressive in nature. And the wedding websites will be customized and tailored through close collaboration with individual couples and will express Miss Smith's and 303's creative messages, including her view of marriage. Viewers of her website will know that the websites are her original work of art. She's not just slapping up a WordPress theme, you know. There are numerous companies in the state of Colorado that offer custom website design services. Ultimately, when this case was being brought up, the district court held that Miss Smith was not entitled to the injunction. So Smith goes in and she says, hey, this law is clearly going to violate my rights. I've got free speech. I've got freedom of religion. It's all protected under the Constitution. You're compelling me to create a website for something that infringes upon my religious beliefs. I'm not going to do it. So I'm asking you, courts, to stop that law from coming into effect. There's an injunction I'm asking you to grant, so this law doesn't come into effect, so that I can go start my side business creating websites. But the court said, no, you're not entitled to an injunction. We're not stopping that law. Make the websites. And the 10th Circuit affirmed. They said, yeah, sorry. But the Supreme Court got this. And Judge Gorsuch, appointed by Trump, drafts the opinion. He tells us the following. The First Amendment prohibits Colorado from forcing a website designer to create expressive designs speaking messages with which the designer disagrees. That's the holding. The First Amendment prohibits Colorado from forcing a website designer to create expressive designs speaking messages with which the designer disagrees. Free speech, free religion, free exercise. Here's what Gorsuch says. The framers designed the free speech clause of the First Amendment to protect the, quote, freedom to think as you will and to speak as you think. Think as you will and to speak as you think. Very important. The freedom to speak is among our inalienable rights, unless you're on a social media platform or an FBI agent. The freedom of thought and speech is indispensable to the discovery and spread of political truth. It's true. That's why they want to censor us. For those reasons, if there is any fixed star in our constitutional constellation, it is the principle that the government may not interfere with an uninhibited marketplace of ideas. This court has previously faced cases where governments have sought to test these foundational principles. In another case called Barnett, the court held that West Virginia's efforts to compel school children to salute the flag and recite the Pledge of Allegiance invaded the sphere of intellect and the spirit, which is the purpose of the First Amendment, to reserve from all official control. State authorities had transcended constitutional limitations on their powers. In another case, the court held that Massachusetts and their public accommodation statute could not be used to force veterans organizing a parade in Boston to include a group of LGBT people, because the parade was protected speech, and requiring the veterans to include voices they wished to exclude would impermissibly require them to alter the expressive content of their parade. Okay, so these are other cases the court is referencing. They've said we've already ruled on these things previously. And in another case, in Boy Scouts of America versus Dale, when the Boy Scouts sought to exclude Assistant Scoutmaster James Dale from membership after learning that he was gay, the court held the Boy Scouts to be an expressive association entitled to First Amendment protection. The court found that forcing the Scouts to include Mr. Dale would undoubtedly interfere with its choice not to propound a point of view contrary to its beliefs. Gorsuch continues. He says, you know, all of those historical precedents have meaning. There's logic behind them. There's something called stare decisis in the law, which means we're trying to build upon other cases. We're trying to have some consistency and logic over the era of hundreds of years. We don't want courts to act like Congress and to act like they can just manipulate things all over the place and just waffle from court to court. There should be consistency because these are principles that are rooted in inalienable rights that are all beneficial for society, like free speech, like free association, like free religion. These things are incredibly important. And so if you're coming from that base layer, you shouldn't deviate too far off of those. Gorsuch says, with all of that in our case precedent, these cases illustrate that the First Amendment protects an individual's right to speak his mind, regardless of whether the government considers the speech sensible and well-intentioned or deeply misguided, and likely to cause anguish or even incalculable grief. Generally, the government may not compel a person to speak its own preferred messages. That's compelled speech. So applying these principles to the parties' stipulated facts, the court agrees with the 10th Circuit that the wedding websites Ms. Smith seeks to create are as pure speech as protected by the First Amendment under this court's precedents. The websites are speech. Ms. Smith's websites will express and communicate ideas, namely those that celebrate and promote the couple's wedding and a unique love story, and those that celebrate and promote what Ms. Smith understands to be marriage. Speech conveyed over the internet, like all other manner of speech, qualifies for First Amendment protections, unless you're outsourcing it to the big tech companies like the FBI did. Then they don't really care about those protections. Literally, they don't care. They just outsource it. And the court agrees with the 10th Circuit that the wedding websites Ms. Smith seeks to create involve her speech, a conclusion supported by their stipulations. The government, or in this case, the government of Colorado even agrees, including that Ms. Smith intends to produce a final story for each couple using her own words and her own original artwork. And while Ms. Smith's speech may combine with the couples in a final product, right? The couple's going to come in and say, these are our names, and this is what we want. An individual does not forfeit constitutional protection by combining multifarious voices. Just mashing them together doesn't automatically make her non-protected under the Constitution. Gorsuch continues. He says, Ms. Smith seeks to engage in protected First Amendment speech. Colorado seeks to compel speech that she does not wish to provide. As the 10th Circuit observed, if Ms. Smith offers wedding websites celebrating marriages that she endorses, the state intends to compel her to create custom websites celebrating other marriages that she does not. Colorado seeks to compel this speech in order to, quote, excise certain ideas and viewpoints from public dialogue. The elected bureaucrats want to excise certain ideas. Indeed, the 10th Circuit recognized the coercive elimination of dissenting ideas about marriage. They said that that was Colorado's very purpose in seeking this law. But while the 10th Circuit thought that Colorado could compel speech from Ms. Smith consistent with the Constitution, this court's First Amendment precedents teach otherwise. In other cases, the ones we just talked about, Hurley, Dale, and Barnett, the court found that governments impermissibly compelled speech in violation of the First Amendment when they tried to force speakers to accept a message with which they disagreed. Here, Colorado seeks to put Ms. Smith to a similar choice. If she wishes to speak, she must either speak as the state demands she speak, or face sanctions for expressing her own belief, sanctions that may include compulsory participation in remedial training, filing periodic compliance reports, and paying monetary fines. This is an impermissible abridgment on the First Amendment right to speak freely. So she doesn't go in there. She's opening up this new website service. Same-sex couple comes in, make my website. She doesn't file this lawsuit. She says no. They sue her because she's not clarifying her rights She loses the lawsuit because everybody in Colorado, even the district court and the Court of Appeals there, 10th Circuit, agreed. Said, no problem. You are compelled to do this. So she loses her lawsuit after she is sued, and then she faces sanctions, theoretically. Mandatory retraining. You're not woke enough for us, so you got to come in here and learn more. You're going to be accepting this. Let me explain to you why the Bible and your beliefs are wrong. Stop being a bigot. Get back out there and make those websites. And we want to check in with you. So every quarter, we want to see how many same-sex websites you've made. And you're also going to pay monetary fines on top of that for not speaking appropriately. Under Colorado's logic, the government may compel anyone who speaks for pay on a given topic to accept all commissions on that same topic, no matter the message, if the topic somehow implicates a customer's statutorily protected trait. It would be nuts. Taken seriously, that principle would allow the government to force all manner of artists, speech writers, and any others whose services involve speech, like yours truly, to speak what they do not believe on pain of penalty. The court's precedents recognize the First Amendment tolerates none of that. To be sure, public accommodation laws play a vital role in realizing the civil rights of all Americans, and governments in this country do have a compelling interest in eliminating discrimination. This court has recognized that public accommodations laws vindicate the deprivation of personal dignity that surely accompanies denials of equal access to the public establishments. Gorsuch says, over time, governments in this country have expanded public accommodation laws in notable ways. Places like Colorado's and their statutes grow from non-discrimination rules in the common law, sometimes that we saw in hotels and restaurants. Those enterprises oftentimes exercise something like monopoly power. But states expanded their laws to prohibit even more forms of discrimination. Today, Colorado, approximately half the states have laws like Colorado's that expressly prohibit discrimination on the basis of sexual orientation. The court has recognized this as unexceptional, saying states may protect gay persons just as they can protect other classes of individuals in acquiring whatever products and services they choose on the same terms and conditions offered to other members of the public. There are no doubt innumerable goods and services that no one could argue implicate the First Amendment. But at the same time, the court has long recognized that no public accommodations laws is immune from the demands of the Constitution. And so, for example, like if you wanted to go and discriminate against somebody in a grocery store, for example, that would not be appropriate because that does not implicate free speech rights. Well, I'm not going to serve, let's say I'm not going to make a website for you, but you can buy a computer from us and make your own website because one implicates speech, the other does not. You can buy our software and create your own website, but we're not going to do it because I have to mix my speech with the product to create the site. In particular, this court has held public accommodation statutes can sweep too broadly when deployed to compel speech. As in those cases, when Colorado's law and the Constitution collide, there can be no question what must prevail: the Constitution. And as the 10th Circuit saw it, they said, Colorado does have a compelling interest in ensuring equal access to these goods, and no option short of coercing speech from Smith can satisfy that interest because she plans to offer other unique services that are by definition unavailable elsewhere. In some sense, of course, her voice is unique. So is everyone's. But that hardly means the state may co-opt an individual's voice for its own purposes. The speaker in the other case, Hurley, had an enviable outlet for speech, and the Boy Scouts in the Dale case offered an arguably unique experience. But in both cases, this court held that the state could not use its public accommodation statutes to deny a speaker the right to choose the content of his own message. A rule otherwise would conscript any unique voice to disseminate the government's preferred messages in violation of the First Amendment. Colorado now seems to acknowledge that the First Amendment does prohibit it from coercing Miss Smith to create websites expressing messages with which she disagrees. So alternatively, Colorado is saying, well, I mean, it does kind of force her to do that. But alternatively, Colorado contends, they say, well, Miss Smith must simply provide the same commercial product to all. The same example. It's like she really isn't creating a website that is her speech. It's just a commercial product. It's just a website. She can just simply repurpose websites that celebrate marriages that she does endorse for marriages that she does not. So just, repurpose it. It's just a template. Just redo it. And so it's not actually speech. It's the same thing as buying a hard drive or a computer or pumping gas or going to the grocery store. Colorado's theory rests on a belief that this case does not implicate pure speech, but rather just a product, and that any burden on her is just incidental. Make the website. It's just clicks for you, bigot. On the state's telling, then speech more or less vanishes from the picture, and with it, any need for the First Amendment at all. Colorado's alternative theory does not sit easily with its stipulation that Miss Smith does not seek to sell an ordinary commercial good, but wants to create a customized and tailored website. She's just not throwing up a landing page. She wants to celebrate and promote the couple's wedding and the unique love story. And so Colorado seeks to compel just the sort of speech that it tacitly concede lies beyond its reach. Gorsuch says, the state stresses that Miss Smith offers her speech for pay and does so through the company, which is the sole member owner. But many of the world's great works of literature and artists were created with the expectation of compensation. So they're saying that, well, she's being paid for these websites, that makes it commercial. So therefore, she should be compelled to transact in a way and communicate in a way and do work that we want her to do. And speakers do not shed their First Amendment protections by employing the corporate form to disseminate their speech. They're like, well, it's not real speech because she's getting paid for it. Colorado urges the court to look at the reason Miss Smith refuses to offer the speech it seeks to compel. And it claims that the reason she objects to the protected characteristics of certain customers is for another reason. But the parties state to the contrary. They say, no, Miss Smith will gladly conduct business with those having protected characteristics so long as the custom graphics and the websites that she's asked to create do not violate her beliefs. So as we said, she'll make a website for a same-sex couple for any other purpose, whatever they want. Miss Smith stresses that she does not create expressions that defy any of her beliefs for any customers. So even if, let's say I imagine she's against pornography, for example, right? Probably doesn't comport with her biblical beliefs. So if somebody came in here and said, we want you to make us a porno site, she would say, no, we're not doing that either. But it's about alignment with her religious beliefs and her speech rather than a commercial product. Whether that involves encouraging violence, defaming other people, or promoting views, she's not going to do it. So the First Amendment protections belong to all, says the judge, not just speakers whose motives the government finds worthy. In this case, Colorado seeks to force an individual to speak in ways that align with its views and defy her conscience about a matter of major significance. In the past, other states in Barnett, Hurley, and Dale have similarly tested the First Amendment boundaries by seeking to compel speech they thought was vital at the time. But abiding the Constitution's commitment to the freedom of speech means all will encounter ideas that are misguided or even hurtful. Yeah, it's a bumpy world out there. People are going to say offensive things. If you don't like it, don't talk to that person. Change the channel, go hang out with a different crew. Don't do business with those people. Don't associate with those people. That's freedom. But not everybody is going to be compelled to create this world that is sufficient to your subjective experience. Sorry. Consistent with the First Amendment, the nation's answer is tolerance, not coercion. The First Amendment envisions the United States as a rich and complex place where all persons are free to think and speak as they wish, not as the government demands. Colorado cannot deny that promise consistent with the First Amendment, and therefore this case is reversed. 6-3 by Judge Gorsuch, delivering a nice opinion, protecting free speech, protecting religious freedoms in America. And let's take a quick look at the dissent and see where this goes. I wanted to see if I could find it, because I think Sotomayor, here she is. Judge Sotomayor, dissenting, joined by Judge Kagan and Judge Jackson. Here is what she says. 5 years ago, this court recognized the general rule that religious and philosophical objections to gay marriage do not allow business owners to deny equal access to goods and services. Now, this court recognized that there was a stigma, but today, for the first time in its history, as they always say, grants a business open to a public a constitutional right to serve members of a protected class. That's not true. It's true in limited circumstances, but this is an overbroad statement, as we just got clear about, right? There are different things that we can pull out of the main opinion. This woman didn't just say, I'm going to refuse all gay people. That's not this case at all. It's a legitimate religious belief that combines her speech with the request of the work product, and it implicates speech. It's not something that is just a commercial transaction. So if even in this case, if a same-sex couple wanted her to make a website about any other purpose, she would have done it. So this is very overbroad, and I think it is a misstatement, actually, of what the ruling is. Specifically, the court holds the First Amendment exempts, this is more specific, exempts a website from a state law that prohibits the company from denying wedding websites to the same-sex couple if they choose to sell those to the public. Now the court is facing a similar test. And let's see what they're saying here, the crux of this. Giving us some background on the law. And saying the legal duty of a business open to the public is to serve the public without unjust discrimination. It's deeply rooted in our history. And she's going to give us a big, long explanation here. It's kind of a long dissent. Let's see how she concludes this. Long dissent from Sotomayor. She says, I fear that the symbolic damage of the court's opinion is done. But that does not mean that we are powerless in the face of the decision. The meaning of our Constitution is found not in any law volume, but in the spirit of the people. This is a judge talking. Every business owner in America has a choice whether to live out the values in the Constitution. Make no mistake. Invidious discrimination is not one of them. The unattractive lesson of the majority opinion is this: what's mine is mine, what's yours is yours. The lesson of the history of public accommodations is altogether different. It is that in a free and democratic society, there can be no social castes. This is amazing. These are from the same people that literally put people into buckets all day. They label people with letters and different demographics, and you can't go into certain colleges until yesterday unless you had certain checkboxes. They literally create them. This is their whole structure. And for that to be true, it must be true in the public market. For the promise of freedom is an empty one of the governments if it's powerless to ensure, because whatever, she dissents. All right. So that is the opinion, and it is a good opinion because this is America, and if you want to comply with the Constitution, you have to stand firm on these freedoms. And there are consequences for this. There will be consequences for the businesses that have these beliefs. Maybe they get more business from people who are aligned with them. Maybe they get less business. Maybe people do business with people they want to do business with. That's a better structure for a free society than compelling people. You have to play nice together. You have to do this thing that you absolutely don't want to do, and we're going to force everybody to get along because some people want society to be elevated to make their subjective experience exactly what they want, all in the name of progress. It is antithetical to freedom. It is antithetical to free speech, to free religion, and the Supreme Court rightly rectified that today. All right, my friends, and so that was our second opinion. Some serious Supreme Court business today. But we're not done yet. And so now that we've got that heavy lifting out of the way, let's see what the heck is going on over in France, because there is a lot going on over there. It's the summer of love in France. What we saw happen here in America, the fiery but mostly peaceful protests, seems to be recreating itself for the French. You see, this is an image of just one set of burning buildings and cars on display on the streets out and around Paris. This is what the map looks like. Lots of rioting taking place. We're going to go through the backstory here. Why is this happening? Apparently, there was a 17-year-old man who was shot and killed by a French police officer. And so that triggered a bunch of people to go really rebalance justice in society by looting stores and burning buildings down, as we saw happen here in America. And so here is a quick montage of exactly what this looks like on the streets of France. That's going to bring some harmony now to society. That's a bigot's car. That's a racist car. Those cars were responsible for discrimination. So this is good. That building, now that this building is on fire, we're going to have more equality in our society now. So, all right, so this is going to be things are getting much better in France now that this equitable movement is underway. You can see also, in order to rebalance the injustices in society, we have to extract property and cars from this building, which will resolve a lot for us. Nice. Justice. Yes, baby. Down with the patriarchy. All right, we're getting equality in France now. Don't know what's in that building. We need to go further. We need more justice. More justice. Get in there for that justice. Perfect. Get that equality out of that building, man. One more time. One more time. All right, get in there. Yeah. All right, get in there and get that equality. All right. So here is another real important thing that happened. Very important to burn down the libraries, because the libraries have, you know, things like books in them, and books contains things like knowledge and truth. And, you know, a lot of patriarchs and white guys wrote a lot of those books. So 830 years after 9 million books in Nalanda were burnt by Islamists, the largest public library in the city of Marseille in France has been set on fire. The largest public library in France, Marseille. Knowledge is everything, but the villains know better. That's why they delete this stuff. And you know what's so funny about this one is this guy actually posted his, I think, Snapchat for everybody to see. That's how proud they are. So libraries are racist and bigoted, so they got to go. Burn those books down. Yeah, so that's what's going on in France. Very, very, I would say, progressive. Definitely not going to happen here again. You see, the police are having a difficult time responding to all of this. Marseille is how you say it. Sorry, I'm not French. Marseille is the city that was burning down. This is the police traveling around the streets of France. Looks like a scene out of a movie. One more time. Streets of France. So we have the streets now like Mad Max on display. Here are thousands or hundreds of cops all charging the protesters. Look at those people. It's almost like an insurrection's happening or something, but except this one's like real. And boy, could you imagine if this was happening on the streets of Moscow? If the Wagner group was over there engaged in this in Russia, what the media would be saying about this? But this is what Paris looks like. This is right outside of Paris. Okay, this is in a supposedly developed country that is definitely sophisticated and basically the path that our government wants to take us on. Here is what it looked like the following morning as this is going to rebuild society by torching society. Okay, well, what the heck happened here? We're going to listen to some response. The timeline is interesting. Over from France24.com, we have an interesting development. Let's go through and break down what's been happening over the last few days. Starting here, 3:10 p.m. Here's what we see. Look at the scene here. This car is just torched. A vehicle burns during clashes between protesters. A 17-year-old boy was fatally shot by French police in a Paris suburb of Nanterre, June 29th. So then everybody started rioting. 40,000 police officers deployed across France. 4 times the number that were mobilized just on Wednesday. Few signs the government appeals are going to be de-escalating violence. There's a working class town called Nanterre, western outskirts. There was a boy named Nahil M. Nahil M. No last name because he's underage, 17 years old, shot dead on Tuesday. After that happened, protesters torched cars, barricaded streets, hurled projectiles at police following a peaceful vigil. Protesters scrawled vengeance for Nahil across buildings, and as the night set a bank that was lit on fire before firefighters put it out. A Nike shoe store was broken into. Lot of racism in there that needed to be equalized. 14 people were arrested on that one. 16 more were arrested with stolen objects after store windows were smashed. National police said on Thursday night officers faced new incidents in Marseille and Lyon and Pau and Toulouse and Lille, including fireworks and fires. It got worse. Here's the scene. 421 people were arrested nationwide. That was as of 4:05. Oh, gosh. We don't want to watch the ads.
According to Le Figaro newspaper, there have been so far 421 arrests nationwide, more than half of them in the Paris region, with the majority aged between 14 and 18. This follows the Interior Minister Gérald Darmanin, who announced earlier the quadrupling of the number of security forces in the streets to 40,000. Bus and tram services in the Paris area, meanwhile, were shut down before sunset to protect commuters and drivers alike, while in some suburbs, an overnight curfew has been announced.
Looks like total warfare out there. So at 7:12, Macron was holding crisis meetings after a third straight night of violence. He's going to cut short a trip to Brussels to chair the meeting, second in many days Elysée said. Now the numbers were up to 667 people were arrested. Wow, they arrest their rioters, though? A total of 667 people were arrested, according to the Interior Minister. Here's some more scenery of blown out windows. That's the Nike store. Hopefully that righted a lot of the historical inequities and the police violence. Hopefully those shoes will help quell future police attacks. So that's public buildings, shopping centers were the targets of the attacks, including a city building. A police station was hit with a Molotov cocktail. I wonder if Kamala Harris is going to post a bail notice about that one on her Twitter account. According to regional authorities, an elementary school and a district office was also set on fire. In Marseille, a library was vandalized, according to local officials. Scuffles broke out, tear gas dispersed a group. Multiple public buildings were also targeted. In Drancy, rioters used a truck to force open the entrance of a shopping center, which was then looted and burned. Firefighters in the municipality dashed from blaze to blaze, and there were tensions all over the place for a long time. Here, 8:57, more looting, third night of violent unrest. And then finally, the French Prime Minister, Elizabeth Borne, said on Friday she had gathered ministers at her office to discuss a third night, calling it unbearable, inexcusable. Macron is returning, cutting his trip short to speak about it. He's back in France. Now Elizabeth Borne, the Prime Minister, says all options are on the table, including a state of emergency. Says we're looking at all options now, with one priority: restoring order throughout the country. Then, now the UN is speaking out. Here we go. Deep racism in law enforcement. Ravina Shamdasani says this is a moment for the country to seriously address the deep issues of racism. We also emphasize the importance for peaceable assembly. We call on authorities to ensure the use of force by police is done proportionally. Yeah, so the police, make sure you don't hurt any of the people who are torching your city, literally burning your city to the ground. Be nice to them. Don't be racist to them. All right. Paris transport disrupted after 12 buses were destroyed. That's nice. A public transport in Paris was disrupted on Friday after protesters, angered by the killing, destroyed a dozen buses. Probably, were those police buses or just no, probably not. There was very significant damage, but nobody was hurt. On Friday morning, 23 bus lines were out of a total of 350 in the city. So the transportation grid is falling.
And the epicenter of the unrest has been in Nanterre, where Nahel had lived. France 24's Mark Owen standing by there, and we can speak to him now. Hello to you, Mark. So one of the options being considered at the moment is a state of emergency. What are you hearing?
Exactly that kind of echo coming through around here too. Elizabeth Borne's words, of course, no sooner said, transmitted all around France, and that possibility of a state of emergency is something that frankly is welcomed by many of the shopkeepers where I'm standing right now in Nanterre. All around me, windows have been broken, the glaziers are moving in to cash their business and of course to replace the damaged panes of glass. Behind me is the building that was set on fire last night, a branch of the bank Crédit Mutuel, and above that apartments are occupied by families, an incredibly dangerous situation. And I think many people around here might welcome that idea of a state of emergency. Of course, there'll be those who'll say it's an infringement of civil liberties, but the situation as it is on the ground with things spreading, clearly some action needs to be taken. 40,000 extra police, of course, have been put into operation to try to control things. That clearly isn't working.
Yeah, and Mark, Thursday, the third night of unrest, many holding their breath about what this weekend, what Friday and this weekend might hold. What have people been telling you there in Nanterre?
It's exactly that. One doesn't know quite what will happen next. The inevitability that people here think will happen.
So they're still piecing together what's going on. Residents expect more of the same after the third night, which is not good. It's the weekend now. French city of Marseille bans protests this Friday. Marseille has decided to ban public demonstrations this Friday after last night's violence. All public transport in Marseille is going to stop from 7 p.m. local time today. Now we're up to 875 people arrested. 492 buildings damaged, 2,000 vehicles burned, 3,800 fires started, according to Macron. Paris is now halting buses and tram services, all stopped until 9 p.m. The early shutdown was for passenger safety. And then Macron speaks. He said on Friday that additional security forces would be deployed to contain the unrest in the wake of the killing of Nahil. Addressing a crisis meeting of ministers, he said additional means would be mobilized by the Interior Ministry to deal with the violence, denouncing the unacceptable exploitation of a death of an adolescent. He also called on parents, keep your kids off the streets during these riots, and he called on social media outlets to remove sensitive rioting content. Whatever that is. So they want more censorship. I wonder if they're going to do like Trudeau did, that little dictator in Canada, and start cutting off bank accounts and stuff. We'll see. Although those were white protesters, so we'll see. UK warns citizens traveling to France about unrest. Certainly looks that way. Here is what Macron said.
Trying to actually go to the French president now. He is speaking and addressing the violence happening in France.
Some people are trying to exploit this opportunity to attack our institutions. They have a huge responsibility, and I fully blame this violence, this unjustifiable violence. Faced with this, on the whole of France, our response was adjusted, people with a lot of cool responded. Now, this afternoon, we took a number of measures with the various departments. The Interior Minister will have to mobilize more resources, and we deploy additional resources for the minister, and there will be a number of circular statements so that minor...
All right, so that's Macron. He says social media platforms should help tame violence. He says TikTok and Snapchat are being used to help rioters organize themselves, and it contributes to the mimicking behavior by some young people, right? So other kids are seeing other kids do this, and then they go out and they do it. They repeated what they saw online. He says it sometimes feels like some of them relive in the streets the video games that have intoxicated them. It's about video games too. Video games and TikTok. So France says that they're going to be restricting public transport. They're also cutting off fireworks sales, saying bus and tram services nationwide halt on Friday. Sales of large fireworks will be banned. The statement said that regional prefects who are in charge of security around the country would also be asked to ban the sale and transport of petrol cans, acids, and other inflammable liquids. So they're gearing up. Poverty is also to blame. France says gendarmes to use armored vehicles now against the riots. The gendarmerie, which I guess is a French word, I'm sure I'm butchering that one too. Prime Minister Borne said Friday, after 3 nights of violence following a deadly shooting, says additional mobile forces are now being launched, including we're canceling large-scale events and other things. France rejects the UN. The UN says your police are racist. They say, no, they're not. Any accusation of racism or systemic discrimination in the police force is totally unfounded from the UN. And now a man dies. Some man jumped out of a building, died last night. Rest in peace. So you see, it's pretty messy over there. And what's so funny is we finally heard from Macron, but that's after some time elapsed. Macron was previously dancing the night away to Elton John. And here's what it looked like when he was getting his groove on. Just a little shimmy. Just a little bit of a shimmy. Meanwhile, justice is being served on Nike stores. Not looking good. But Elton John, he delivers a good show, I'm sure. So that was Macron. That's what's happening in France. And it is troubling. It doesn't look all that different from something that our country experienced in 2020 and may very well likely experience again, because as the Democrats and as a lot of the Republicans too, our power officials, the people in charge, they love to just pit everybody in the lower class, which is everybody except them, against one another. It's why we have endless battles with each other over all sorts of things. We're now down to even pronouns now. That's how minute we have come with our divisions in our society. And so it's happening in France. It's very possible that it could happen here in the United States again, maybe even to a bigger extent like this is, especially on the back of Supreme Court rulings, as the wealth gap continues to increase, as the middle class continues to get obliterated. We're now going to see what I believe to be class warfare come back into play, along with gender warfare, along with orientation warfare, along with racial warfare and religious warfare and pronoun warfare, and the list goes on and on. So it's happening in France, maybe the canary in the coal mine, as other Western nations continue to devolve into madness. We'll continue to cover, my friends. But that is it for us on the day. And now let's see what you have to say about all of this and more. What's going on in France? We've got 2 Supreme Court opinions to attend to. And so now let's check in with you, my friends, and your amazing contributions to the work that we do here on YouTube, on Rumble, on Locals. We'll say hello to Twitter. Big welcomes to Christopher Lopez coming in over on YouTube. Thank you, Christopher. Welcome aboard as a new member in our community. And thanks, John, for clipping away for us. Spuds is here, says, for many, college is just a 4-year daycare. You could say that about law school too. Law school is just another 3 on top of that. In fact, that's what it felt like when I was there. A lot of people were just like, oh, still kind of just going hog wild there. So that's from Spuds. Thank you, Spuds. Hey, Z's in the house. He says, gay dude here. What's up, Z? Thanks for the super chat. Says, I support the ruling. No idea why we're obsessed with having people who don't support our weddings working them. Your business, so you do you with it as you see fit. We're not all crazy. Let's all get along. I couldn't agree with you more there. It's I would go to some, like we would have people come into our law firm that I would just say, we're probably not a good fit for you, not for any of these reasons, not for any, discriminatory reasons or anything in that category, but they wanted somebody who was different, right? Like I had one case, I'll remember this one specifically because it was like we were early in our law firm and I was working with this guy. I thought he was going to hire us. He didn't hire us. He hired somebody else. And I was like, what? I thought we had like this great rapport. Like we were working on this case and I was kind of hurt by it. But I wasn't the right fit for that guy, right? It wasn't anything because of anything like, demographics or orientation or gender or anything. It just wasn't the right fit. He wanted somebody, and I know the lawyer that he hired, great lawyer, and an entirely different personality than me, okay? Like 100 degrees different. Extremely analytical, doesn't like to communicate a lot openly, very analytical and technical, okay? So just a different person. Like you want to find the right fit for you, no matter what it is. And, having somebody who disagrees with your wedding do your wedding is just like nuts. What? I mean, you would do that even if you were of the same, like what if you went in there and this person who was going to design your wedding website said, I really want to use green and pink. I want to use really dark greens and pink colors. And we're going to use this font called Calibri, and that's going to be your website. You'd say, huh? That sounds horrible. Those colors don't match, and Calibri is a font that is just overused. So I don't want that. And you would part ways on that basis. It's just not a good fit. So when you go in and do business with somebody who has a values disagreement with you, it's like, what are you doing? Go to the next store. It's America. You know, and I think that applies to everybody. But, you know, Z, the real crux of this comment is, unfortunately, I think people will see these little openings in society and try to exploit them. And they want people to have their behavior compelled, so that there are no more of these bigots out there in society, you know. And it's the same pattern we saw with the jab. It's like, hey, get the jab or lose your job. Get the jab, get thrown out of the military. Bake the cake or lose your livelihood. Make the website or you're done to us. We'll sue you, we'll put you in remediation, and we'll hit you with sanctions and fines. Same thing. So thank you for being here, and thanks for sending in this super chat. I 100% agree with you. And you know, I suspect many, many, many other people do. And that's a good thing. I think a lot of other people would, because think about it the other way. It's like, what if you were, I don't know, a gay website maker, or you were a gay person who made websites, and somebody else came in and said, I want to make a website that says that all gay people are, you know, immoral. Make the website. Make it. And you say, well, you know, I prefer not to work on that project. And I would say to you, tell that person to get out of your store. I'm not interested in that project. Thanks. It is values opposed to me. I don't think you should make that website for that person either. It goes both ways. But the people who want their viewpoint to be coerced and impressed upon everybody else, they want to use that power. The rest of us don't. All right. So thank you for that, Z. Great comment. This one from Rivka, the Jade Gamer, over on Rumble. Thank you, Rivka. Sounds like you've got a Rumble channel, which is awesome. Says 15th SCOTUS win for Alliance Defending Freedom since 2011. Founded in Scottsdale, Arizona. I did not know that. I did not know that. You should request a media interview. How cool is that? Thank you for enlightening me on that. They're here? That's great, man. There's a lot of awesome people here in Arizona, by the way. Ryan Heath is another great lawyer here who I had the pleasure of having coffee with. He's on Twitter. He's doing some cool stuff. Ryan Heath. And then Garrett Ziegler is in Tucson, or last I checked, he was in Tucson, right around the corner. So we got some good people working on some good issues here. Thank you for that, Rivka. Good knowledge. Good to know that. All right, Steve Bolin became a supporter on YouTube. Welcome aboard, Steve. It's going to be great. So I'm doing a little traveling this weekend and going to be posting some members only stuff. And so members, stay tuned. Should be some fun stuff, a little bit different stuff coming up. Alexandra's here, says, hey, Rob, thank you, Alexandra, says, could this also be used in relation to defense against big tech censorship? Asked in the chat, but would love to hear your thoughts. So I'm trying to think about which case now we're talking about. Defense against, maybe the website case, saying that was it the website case? Is that comment related to? It's got to be that one. I'm trying to think how it might be useful in that argument. So in this case, we had a business owner who says, I want to clarify my rights and be able to reject certain business arrangements. I think, you know, if you're going to analogize in any way, I think that the analogy would be big tech could say that, you know, you can't force us. I see what you're saying. Maybe they can be prohibited from forcing you to speak a certain way. But are they compelling speech, or are they just prohibiting certain speech? Yeah, I think it's, and again, it's a private, so I don't think it's going to be very useful, because the distinction here, the big key distinction, Facebook's a private company. This was a Colorado law. This was the state coercing a person into doing something. Facebook is different. Facebook's a private company. So that's why the FBI was outsourcing their stuff to Elvis Chan and the Facebook people, because they couldn't do it on their own. They knew it was unconstitutional, which is why they outsourced it. So it's a great question. I was trying to dig and see, is there anything there, but I don't think that there is offhand, but it's a great question, Alexandra. This one came in from Zulu. Says, as a law school graduate, that's true. I also do have my license in two states, but that's true. I did graduate. Says, can you check the following statement for legal accuracy? It is written in our founding father laws that no other religion was allowed on the United States soil but Christian Judeo values. I don't think that's an accurate founding father laws. I don't think that's an accurate statement in, for example, the Declaration of Independence or the U.S. Constitution. I think you could say that in the Federalist Papers, they talked a lot about Christian Judeo values. In other writings, maybe not the Federalist Papers per se. In the Federalist Papers, I don't think they mention that specifically. But you could make the argument that a lot of the early founders were Christian and deists, and that they had faith, and that I think you could make the argument that there are connections to the concept of inalienable rights and natural rights. A lot of that comes from theist religion, from this idea that the human being is special. There are other ideologies that think that the human being is really not all that special, and that the human being is just kind of an animal that's just like a meat puppet, and that you don't really have any real values or rights or any real value as a human being. I think, if you look back in the history books, until we really, reach kind of an era of enlightenment where we started to value humanity, and you can go back to John Locke and Adam Smith, Wealth of Nations, and Tocqueville, that was after the founding, but even the founding area, people before that, like Rousseau and Hobbes and these people, the world was a very, very tumultuous state. Hobbes talks about it as a state of war, that society, that the natural state of life is a state of war. He writes about that in Leviathan. And it's a scary state of affairs when everybody literally is killing each other. So if the base layer of society is just all-out war and murder, for most of human society, like think about, just think about any of the barbarian states, and even back in the Roman, Greek era, and the Dark Ages. It was a very, very difficult time, and humanity didn't have a lot of value. And so then we started this era of enlightenment, and we started to say that free speech was important and free thinking was important. And then we, extrapolated a lot of that from Christian values, which said that we were born and sort of God-given, inalienable, immutable rights that I think inspired a lot of the Enlightenment thinking, which led to some of, the Western traditions that we have today. So I would agree that, the Declaration of Independence and the U.S. Constitution don't specifically say, this is a Christian nation. Like, that's not in there. But that doesn't mean that a lot of those principles were not integrated or intertwined into the thinking that was around at the time. And this is a pretty important concept. This is when, oftentimes when you're creating a new structure or a new system, you do want to make it a little bit more generic and, homogenize it a little bit so that it applies to everybody. And, actually the big book, the 12 Steps AA, talk a lot about that. Or there was some conversation about the 12 Steps and the big book of Alcoholics Anonymous wanting to be more Christian, but then they sort of sanitized it of the Christianity without really doing it so that it would apply to more people. Because if you make it outright Christian, then you're sort of alienating other people who might get a benefit from the steps from the program. So kind of, a same type of thing with the Constitution. If you really wrote it in there, then it would obviously go against your if the First Amendment says free exercise of religion. So it would be going against that. So, they were very smart people, and I think they were very logical and consistent, and they adhered to free association of religion, but it doesn't necessarily mean that those things weren't interspersed in there. But that's only a very base layer answer from a mere law school graduate. Thank you, Zulu, for the very generous chat on that one. I appreciate you being here. Lady Freddy's here, says, just checked in on you, but Project Veritas just exposed Plan B for loan forgiveness. I wonder what Plan B is. I'm sure there'll be a lot more They're not going to give up. They're still the same people. The Supreme Court might have made a ruling, but we're still battling the same people who are still going to do the things that they do, which are not often honest. Wolfgang says, burn those racist cars. How dare they discriminate? Oh, yeah. Was it Project Veritas or was it OMG? That's the question. OMG or Project Veritas? Wolfgang says, burn those racist cars. He says, say. It's Marseille. Not, what did I say? Marseille. It's not Marseille. It's Marseille. He says, I've been to Marseille in the south. Wow. Big. I think I've been to Marseille too. Now that I think about it. I think I traveled there and visited a castle or some grounds out there. I traveled out there years ago in college. Wolfgang says something about get rid of the rioters. Either we be Solon or give Draco. I don't know what that means. But Wolfgang says, why are all publicized shootings racism? No UN. And says, is anyone up for a party in Marseille? No. No. Don't go to Marseille. It's a bad place right now. Isaac Bowles, and thank you for all of those, Wolfgang Deos. Some of those I didn't put up on the screen, but thanks for sending them in. Isaac Bowles says, the perfect mixture of serious legal analysis and sarcasm is the reason this is my favorite law channel. Well, thank you, Isaac. Yeah, sometimes we do some legal analysis. Sometimes we do some sarcasm. Sometimes we do a lot of sarcasm and really lay it on thick here. So I'm glad you're enjoying it. But we try to keep it fun and lively. I know the legal analysis sometimes can be some heavy lifting, so we try to spice it up. But thank you, Isaac, for being here. Thanks for joining what we do. We got this from Baked Turkeys. Baked Turkeys is in the house. Says, do you think the ruling against affirmative action would have achieved the same ruling if the plaintiffs were white? Good question. The amount of anti-white racism I've seen the last 10 years is atrocious. Yeah, I don't know. Actually, I don't know about that. Maybe not. Maybe not. I think the absolute, like the discrimination against Asians was clear and on display, such that it was almost undeniable. And also, Indians and Middle Eastern, right? Those were other categories that like really weren't considered. It's like, well, you're kind of too smart. You're a little overrepresented. Stop working so hard, or something. So but they're definitely not white. And so you can compare and contrast, that category to the other categories. And then you can see an obvious difference. But if it's white people complaining, they just say, well, you're white though. So you've had this country for 400 years or what, they don't even know anything. So they just make up numbers. But that's my point. So I'm not sure, about it. I'm not real sure what the Supreme Court would have done or where it would have gone. It's a great question. The amount of anti-white racism I've seen in the last 10 years is atrocious. It is true. It's basic, it's now called equity, and they can just be bona fide racists. So Wolfgang says, the founding fathers were likely haters of atheists. They would have known about other religions, but no one trusted atheists back then. I don't know about that. I think there are some atheists who say that there were founders who were atheists, Everybody latches onto the founders. No, he was this and he was that. And the atheists say, no, he was an atheist. They were all atheists, which is why there's, freedom of religion. I don't think that's true. So, all right, let's check what's going on Twitter. Say hello to our friends over there. Is anybody watching? Yeah, we got 4 people here. It's a Miracle Friday. Danny McWilliams is here. He says, you only see riots in the city, never in the country. If it were in the country, all you'd see are problems. Omnipotent says, I'm just posting to prove that there is life on Twitter. Thank you, Omnipotent. I appreciate that one. And Danny says, question, all the countries that have free college are so good, then why do people come here to go to school? It's a good question. I don't know. We'd have to ask them, I suppose. But okay, my friends, that was it for us on the day. That was from our friends over on Twitter. We are sticking around for our members on watchingthewatchers.locals.com. We're going to hang out and do a bit of an after party on this lovely, lovely Friday. And so we'd love it if you joined us, watchingthewatchers.locals.com. Going to do some extra member-only stuff this weekend, and it should be some fun stuff ahead. Don't forget to grab your field of greens for this lovely holiday weekend. I know, look, there's going to be a lot of steak, a lot of ribs, a lot of barbecue sauce, a lot of potato chips, okay? Maybe some adult beverages in there. And so balance it out with something nutritious, delicious, so that you can be healthy and well. Save 15% off with Field of Greens at fieldofgreens.com and get your real organic superfood. Also, if you'd like to create a mind map like this one, you can do it at spotlightlawyer.com/mindmap. I love this tool. I use it for all sorts of fun stuff. And I want to thank the mods and the meme smiths who mod down the fort for us. Big thanks to our friends Donut Mind Me, Dog Digger, Janek 909, John Allen, Zach Nichols, Beyond Geo. We got Zulu, Ronnie Cole, Playin' Hooky, Just Cause, K-Bean, and Vientikis Prime, along with John McGarvey, who is clipping away for us. Thank you, John, for clipping away for us today. We've got Sleepy Dog Lee, Geegum Geegum, and our friend Nathan 810 over on Locals as our meme smiths, and they all help keep the show nice and orderly and the train on the tracks, and we're grateful. We have the best mods and the best meme smiths. And so, my friends, that is it for us on the day. We are going to stick around for our after party. If you're a YouTube member, don't forget to grab the Telegram link. You can navigate over to the community tab section. Join us there on Telegram. But that, my friends, is it for us on the day. It's going to be a beautiful July 4th weekend. We are planning on doing shows Monday and Tuesday. I'm planning on it. We'll see. So make sure your notification bells are on and you're subscribed wherever it is you're watching this. And I hope you have yourselves a beautiful, beautiful July 4th weekend, celebrating all the amazing things this country has to offer us. And it still does have a lot. And so we will leave it there. If you're a member, stick around. We'll be back in a minute. Otherwise, my friends, make it a beautiful weekend. I hope you spend some time with friends and family, unplugging from politics, getting some sunshine, getting some vitamin D and some fresh air. And we'll see you right back here on Monday, so that together with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful weekend, my friends. I'll see you right back here on the next one. Bye-bye.